So what is drug possession? In New South Wales, it's a crime to possess a prohibited drug. A prohibited drug includes MDMA or ecstasy, cannabis, cocaine, heroin or amphetamine. You'll be guilty of possessing drugs if you had the custody or control of the drug with the intention to be able to exclude others who aren't acting in concert with you, and you either knew or at least believed that there was a real chance that the drug was there, and the drug is a prohibited drug under the law. So what does custody or control mean? Having the drug in your custody means to have it on you where you're able to exercise exclusive control over it. Having the drug in your control includes to have it in your exclusive control whilst it's located somewhere else other than on you. For example, where the drugs are found in your home, car, or location other than where you are. So how does the prosecution try to prove that you knew that the drug was there? The prosecution will usually try to persuade the court to draw an inference that you knew that the drugs were there based on the circumstances of where the drugs were found. For example, there'll be a strong inference that you knew of the existence of the drugs that were found in a wallet located in your pocket. However, such an inference can be displaced by producing evidence to show that you didn't know. So what are the penalties for possessing prohibited drugs in New South Wales? The offence of possessing a prohibited drug has a maximum penalty of 2 years imprisonment and or $2,200 fine, including a criminal conviction. You can avoid a criminal conviction even after pleading guilty to a drug possession charge. This will occur if the magistrate is convinced to give you a Section 10 dismissal or non-conviction conditional release order. A magistrate can impose a non-conviction order after you plead guilty based on one or more of a combination of relevant factors, such as your good character, your age, your health, your mental condition, absence of any prior offences, trivial nature of the offence, any extenuating circumstances of the offence, and anything else the court considers proper, including the impact of a conviction on your job and the flow-on effect of that on anyone else who relies on your income. A court can impose any one of the following types of penalties for a drug possession offence: Section 10 dismissal, non-conviction; conditional release order with or without a criminal conviction; fine with a criminal conviction; community corrections order with a criminal conviction; intensive corrections order with a criminal conviction; or full-time imprisonment with a criminal conviction. So what are the defences to a drug possession charge in New South Wales? You'll be found not guilty to a charge of drug possession if the drugs were found by police after an illegality by police, such as an illegal search, or you didn't know that the drugs were there, the drugs were found in a common area, such as a house or car, that others have access to, raising what the law considers a reasonable possibility that someone other than you had control of or put the drugs there, or you had possession of a minute amount of drugs, you had possession of the drugs due to a duress or necessity. The prosecution are simply unable to prove beyond reasonable doubt that the substance found was in fact a prohibited drug, you had custody or control of the drugs to the exclusion of others, or you at least believed that there was a real chance that as to the existence of the drugs from where it was found by police. So what are your options in court? You may plead either guilty or not guilty on your first court date for a charge of possessing drugs in New South Wales. If pleading not guilty to a drug possession charge, your case will eventually get adjourned to a hearing date in the local court. Before the hearing commences, the prosecution is required to serve you with a copy of all their evidence beforehand. The magistrate will then hear all the evidence on the hearing day from both sides before returning a verdict of either guilty or not guilty. If you're found guilty, the magistrate will proceed to sentencing and impose a penalty. However, if you're found not guilty, the drug possession charge will simply be dismissed. If you're pleading guilty to possessing prohibited drugs, the magistrate will proceed to sentence by imposing a penalty. If you're not prepared and you require further time to gather character letters for court or seek legal advice, you can ask for an adjournment to be sentenced on another day. Pleading guilty at the first court date will result in a 25% reduction in your sentence. Gathering and using compelling character reference letters for the magistrate to read on your sentence day can also convince the magistrate to give you a more lenient sentence, especially where the reference letters are from carefully chosen referees, particularly outlining your expressions of remorse or insight, good character, impact of a conviction on your job or career. If you think you're suffering a mental condition, it's worthwhile getting a psychologist's report prepared. This can significantly improve your sentence outcome. In some cases, you might even be able to negotiate with the prosecution or police to change the police fact sheet to ensure it accurately reflects what really happened and how it occurred when it's read in court on your sentence.